Restitution damages. So far we've discussed expectation damages, which are the primary measure of damages for breach, and reliance damages, which are an alternative remedy at law when expectation damages cannot be calculated with reasonable certainty. Now we'll begin discussing restitution damages, which are a quasi-contractual remedy that will bridge our conversation into equitable remedies because this straddles the line between law and equity. Restitution is not really a contract remedy. Rather, it's understood best as part of the doctrine and law of unjust enrichment, which is a law that can apply to contracts. The general notion of unjust enrichment is that one party has done something to benefit the other party and had good reason to do so, or was reasonable in making that action, but that good reason is not because the parties have a legally enforceable contract. If they have a legally enforceable contract, the preferred remedy is expectation damages at law. But the parties do not have a legally enforceable contract, which can happen for many reasons. For example, imagine that a man passes out in the middle of a busy street, and a physician runs over to aid him, attending to his wounds, and then sending him a bill for $1,000 for these services. Can our surgeon, our Good Samaritan, receive the $1,000 bill? Well, we can't receive this money under contract law because a contract was not formed. Contracts require mutual assent. An unconscious party cannot assent. That party lacked capacity to contract. So we do not have a contract, and we cannot have expectation damages since there was no bargain. The surgeon cannot make a claim under contract law because the party was not conscious at the time. Even if the revived man promised later to pay for benefit received, that does not constitute consideration. That is a gratuitous promise for benefit already received, which is also not enforceable at law. Perhaps the subsequent promise would become enforceable under the doctrine of promissory restitution, but that is only where the surgeon makes a material change in position in reliance of the promise. It may be the case that contract law simply does not provide a remedy. So is our surgeon out of luck? Fortunately for the surgeon, restitution and the equitable doctrine of quasi-contract and quantum meruit may serve to force the injured man to pay the surgeon for the benefit received. The surgeon will argue that she conferred a benefit upon the injured man, and she may prevail in her claim for restitution. More generally, restitution is a remedy where a contract does not exist. Perhaps there was a defect in contract formation. Perhaps there was a mutual mistake, which renders the contract voidable, or non-compliance with the statute of frauds, which renders the contract unenforceable, or a lack of consideration, which renders the contract void. What happens in these cases where there is no enforceable contract, but one party has performed anyway, thinking that there was one? The non-performing party has been enriched at the performing party's expense. Contract law per se does not provide a remedy, but the injured party may prevail in a claim for restitution. So we see that a claimant entitled to restitution may obtain a judgment for money in the amount of defendant's unjust enrichment. But how do we measure restitution damages? How do we measure the amount of unjust enrichment that must be repaid? In the case of money paid, it is simple. For example, imagine that you give Tesla Motors a $1,000 deposit for a Model 3 to be delivered in November 2017. But Tesla fails to deliver the car. Tesla then claims no contract was formed because the terms are too indefinite. And in the alternative, even if a contract was formed, it's unenforceable because there was no signed writing. Let's assume that Tesla's right and no contract was formed. Does that mean Tesla gets to keep your $1,000? It can't be the right result that Tesla simply gets to keep your money because there was a mistake as to whether a contract was made. Of course you get your money back, but you get it under the doctrine of unjust enrichment. If your breach of contract claim fails, you cannot get expectation damages, but you could require return of your money under restitution. The third restatement of the law of restitution, section 49, says, Enrichment from the receipt of non-returnable benefits may be measured by A, the value of the benefit in advancing the purpose of the defendant, B, the cost to the claimant of conferring the benefit, C, the market value of the benefit, or D, a price that expressed how much the defendant was willing to pay if the defendant's asset was treated as a valid question of price. So we have 4 measures of restitution damages in section 49 of the third restatement of the law of restitution. Which of these usually applies in quasi-contract? Well, as I mentioned, the easiest cases are where the parties intended but failed to form a contract. If the parties intended but failed to form a contract, they probably discussed a contract price. For example, imagine that Sarah agrees to work for Teagan's law firm for 2 years, and Teagan agrees to pay $200,000 for Sarah's work. Sarah works for a year and then quits, and Teagan refuses to pay anything because this is a contract for a term of more than 1 year, and it's not evidenced by a signed writing. Will a court require Teagan to pay $100,000? According to an analogous case, the famous case of Britton v. Turner, the case is almost certainly going to be, yes, there has to be money paid for the time. In Britton v. Turner, a farm owner hired a laborer to work for a year in return for $120. 12 months in a year, so that's $10 a month. The laborer worked for 9.5 months, then quit. The court held that the farm owner had to pay the laborer in restitution for the benefit conferred on the farm owner, which equaled about $96, which was about 9.5 out of 12, or 80% of the contract. And so because there was a contract contemplated, we could peg a price to those services, and since 80% of the work was completed, 80% of the pay was required as a measure of unjust enrichment that had to be returned in restitution. Is anything wrong with that result? That's nice and clean, but think about a time you started a new job. Were you as valuable on day 1 as you were on day 1,000? Most new employees need training at first, and employees have negative value until they're trained. They require inputs, they're cost centers before they're profit centers. Most new employees need training, and so an employer is taking a risk in hiring an untrained employee and training them. Training may not work out. And moreover, as we see, the employee could leave right after the training and maybe get a more profitable job working for someone else who will pay for a fully trained employee. The employer might try to mitigate this risk by paying only for the full term. And so part of that term would be a time where they're losing money and part where they're making money, and they're expecting not 80% after 80% of the time, but 100% after 100% of the time. That's a way that the employer could try to mitigate the risk. Is there any economic reason or moral reason why the law should not allow an employee to bargain for a mitigation of the risk that the employee will leave? Courts should be careful to articulate why they will not allow enforcement of these contracts at will. So usually when we have restitution, equitable remedy, we need to find some amount of unfairness. Indeed, courts in equity should always be careful about their unintended consequences. For example, here, by granting restitution to one employee who has worked and not been paid because the contract would not provide for payment, the court has raised doubts about whether such arrangements will be enforced in the future. That means employers may be hesitant to make these deals and may feel that they cannot shift the risk in the way that they need, since a court may not honor the freedom of contract principle and decide that fairness mandates a different result. The big problem is that this makes an employer less willing to hire an untrained employee, because now they have no way of protecting themselves about that employee collecting after receiving training but not providing value. As a result, while it may result in fairness in this case, it can result in a larger unfairness as people are unwilling to hire the next generation of untrained laborers, who will therefore have more trouble finding work and training as part of their package. So we see that the law is complicated. The courts awarding equitable remedies of restitution mean that we're not observing freedom of contract principles to the fullest extent. The doctrine of restitution and unjust enrichment, however, gives courts some needed flexibility to avoid injustice that could be created by strict adherence to the law. As we've seen, the flexibility creates uncertainty, and unreliability of the law creates its own type of injustice, so courts must be careful to balance these principles of fairness. The key thing to remember, then, is that unjust enrichment should only be applied where there is some fundamental unfairness. Next, we'll talk about duty to mitigate damages, but before we move on to our last topic for today, are there any questions about the doctrine of restitution and unjust enrichment?